The vast majority of companies compile and store information regarding its customers. It's become a daily phenomenon of news headlines involving major data breaches. One of the most notable recent data breaches involved Target, where over 40 million customers had their credit card and debit card information exposed or accessed by hackers. The question is, what are a company's obligations in the event of a data breach? In Arizona, these obligations are set forth by statute. The first thing to consider is what is covered personal information. Statute defines that as there are two elements of it. First, a customer's name, and then secondly, when combined with either the customer's social security number, driver's license number, or critical financial account information. The next issue to consider is what constitutes a breach. For purposes of the statute, a breach is any unauthorized acquisition or access of the covered personal information, and that access has to either cause or be likely to cause substantial financial harm to the affected individuals. The next issue to consider is what are the company's obligations in the event of a breach. There are essentially three requirements. First, the company must have some method in place to detect a data breach. Secondly, when a company has notice or reason to believe of a potential data breach, it must conduct a prompt and reasonable investigation to confirm the breach and determine the scope of affected individuals. Finally, the statute requires prompt notice to all affected individuals. And the statute defines prompt as being in the most expedient manner possible without unreasonable delay. There are a number of takeaway points to consider. Number one, the Arizona data breach statute does not apply to personal information that's stored in an encrypted or sufficiently redacted format. So if you're encrypting your data or redacting it in the appropriate manner, you're not going to be subject to the notification requirements. Secondly, if you conduct business in a specialized industry, such as financial services, education, or healthcare, undoubtedly you're going to be subject to additional federal requirements in the event of a data breach. Third, a company can mitigate the risks of a data breach in advance by purchasing specialized cyber insurance, which will respond to and cover costs associated with breach response. And the next and an important issue to consider is that failure to comply with breach response requirements can result in substantial civil liability. A notable case involved a series of related class actions against a significant educational institution here in Arizona based on failure to comply with the statutory breach response requirements. The final takeaway, and I think the most important, is that in the event of a data breach, it's critical that a company consult both with legal counsel and with specialized vendors to assist in the breach response and in legal compliance.